Welcome back. Well, yes, we turn our attention to matters concerning the fight against corruption. And we're starting off with, of course, one of the agencies saddled with that responsibility is the EFCC. Uwujaren is the spokesperson of the commission. He joins us from Abuja. Morning, and thank you for joining us today. I mean, yes, indeed, the caption, that's where to start. How do we explain this flurry of activity from the EFCC? I mean, we heard several persons said that before now, it just appeared as though EFCC existed on paper.
Thanks for having me. I don't think through this year that we have always been doing what Parliament set up mission that is fighting financial crime. Probably what has happened in the last week is you are seeing very high individuals being brought for prosecution, violating some of the laws empowered to implement. It does not mean we have not been doing that in the past. I'm sure if all that year the Commission achieved 126 convictions, and most media houses said it, we'll be doing that and we'll continue to do that. What I see and it didn't just start yesterday. The investigation relating to some of the governors that were taken to court in recent weeks started way back, sometimes in 2012. Most of those cases have matured now. That's why we are taking them to court.
Okay, I missed out some of the things you said earlier because the sound was fluctuating from our end here. But it took, how long does it take for those cases to mature? Because the FCC, I mean, the former president was there, and you had well over 2, 3, 4 years for some of those cases. Does it take that long for them to mature?
You actually don't put the time back in investigation. And as a commission, we are mindful doing our job to ensure that before we go to court, we have a watertight case that can stand the record of prosecution in court. So it's not for us to rush cases to court. That's why we're taking our time to do some of these investigations that have led to a prosecution that we are seeing lately. If you look at the case of Lamido, for instance, you will recall that in 2012, with $40,000 that he didn't declare. That was what triggered the investigation in Lamido's case. And we have been on that for more than a year, doing investigation underground. We couldn't move against the governor because under the constitution, he enjoyed immunity from prosecution. We had to wait until he left office before we took him. And that also applies to the case of the former governor of Adamawa State, Murtala Anyanko, and also the former governor of Imo State. That one, his whole investigation took a rather long period of time because we wanted to get it right. And now we are in court and we are going to prosecute those cases diligently to ensure that we achieve the desired result.
So you think that by now, okay, you have the investigation, you've gotten it right now, and you're confident that at the end of the day, you will have your way or you have victory in court?
Absolutely. The proof of evidence attached to the charges that we have filed to them are watertight, and I'm very, very convinced that we will achieve the desired result in court.
What did the chairman of the commission mean at the time when he first came in and said he did not want media trial or a lot of all of those cases in the media? And because ever since he said that, the commission literally was not much heard of in the papers, or in the media, I should say.
I think there was a background to that. Prior to his coming on board, EFCC was criticized everywhere that we were conducting our investigation on the pages of newspapers, that we take people to court and so much drama in the activities of the commission. And he was conscious of that criticism. And when he came, he made the decision that, look, we were not going to be announcing investigation or taking to court. We were not going to be announcing that we plan to arrest somebody, for instance. We don't do that. We do our work covertly, and that is the international best practice all over the world. You do your investigation quietly. It's only when you are ready to take on the culprit that you let the people know that this is what you are doing. It has its merit, it has its disadvantage. We are in a society, for instance, where people bandied names about those who are corrupt, and they believe that if you don't announce that you are investigating Mr. B, you don't announce that you are investigating Mr. C, you are not doing your work. That shouldn't be. Now we have a culture that is serving us very well, in which we do our work diligently, quietly, covertly underground. It's only when we are ready to move against that the culprit or whoever has violated any provisions of the law that will not come up publicly to say, okay, we are ready to go to court. All these governments that were taken to court recently, some of them, you didn't hear us talking about investigating them until we were ready to actually move against them and ensure that they are prosecuted.
Mr. Uwujaren, how long does it take you to, between the conclusion of an investigation and going to court? What's the average time frame?
You can't put a time frame on it. It depends on what you have from your investigation. And usually what we do, once the operatives have concluded their investigation, they send their investigation report to the Legal Prosecution Department to file charges. Those ones look at the investigation report and they deliberate on it. If they believe that, yes, you have a prima facie case that can stand the rigors of prosecution in court, they prepare charges and then will file those charges in court. No one can tell you that this process will take 1 week or 2 weeks or 3 weeks. It depends on the evidence that you have and the work that the legal
For instance,
team has to
let me just give you an example that's coming to mind. Someone's actually just brought that up. It just popped up here that you concluded the investigation, you supposedly concluded the investigation of the former head of service, Steve Uwujaren, in 2011, but you just went to court. Is that true?
No, that's not correct. The investigation regarding Steve Uwujaren started in 2011. It started in 2011 when the biometric exercise was commenced. And that process has been on. We have been gathering evidence since then. And now we realize that we have enough to go to court and prosecute him successfully. We should be cognizant of the fact, we should take cognizance of the fact that prosecution is not a matter, it's not a child's play. You don't just take people to court because you want to embarrass them. You must have evidence with which you to prosecute them before you go to court.
So if the EFCC, Mr. Uwujaren, if the EFCC...
You must take your time to do a correct investigation before you take anybody to court.
If the EFCC, as you said, works covertly just to get all the details and evidence needed, how is it then that in almost every case known, the EFCC almost starts out with 50-count charge, gets it reduced to 25, and sometimes goes back up? It's as though there's a yo-yo going back and forth, 50 counts, 25, 30. Why does that happen?
No, I don't think you are correct about that. I don't think there's any yo-yo concerning our charges. If you are talking of EFCC in the past, there was a time when, for instance, you hear us filing 170-count charge in court. But I don't think in recent years you will see that kind of number of count charge in any of our cases. Yes, sometimes the exigency of a case might warrant you amending your charge, and we have the prerogative under the law to amend charges. We believe that it will help our case. We can take advantage of that because the law allows you to amend the charge. But we have not done that deliberately to throw up our case or to set somebody free. No. It is the exigency that you find in court that will determine whether you will amend your charge or not.
Now, what some people will also find a little interesting is that you say that most of the cases that you have now, investigations had been on for quite a while. The question will then be, the cases before 2011, we want to also believe that investigation was on before that time. How come we saw no big prosecutions in between 2011 and 2015?
There were prosecutions. The case of Timothy Sylvia didn't start today. Those cases, that case was taken to court in 2012. And the investigation didn't start in 2012. I just told you that we prosecuted the son of Esule Lamido. He was actually jailed for money laundering offense. That happened in 2011. It didn't happen today. So we have a number of high cases that we took to court prior to now. But yes, now we have some ex-governors that were taken to court that we couldn't have taken to court because they enjoyed immunity under the Constitution. It does not mean that we have not touched high-profile cases prior to now.
The former governor of Imo State stopped enjoying immunity a long time ago. He's only just resurfacing in court again. There are quite a number of governors or former governors whom you have been prosecuting before now, and nobody has heard anything from the EFCC again. Are those cases over?
Absolutely, they are not over. If you have been tracking cases in court, you will recognize that most of those cases are still ongoing in court, especially the set of cases that we took to court in 2007, way back in 2007, the first generation of former governors that we took to court. Some of those cases are still dragging in court because of several frivolous applications that the accused persons have filed in court. And if you are familiar with the adjudication in Nigerian courts, you know that there are several hurdles that accused persons, defense counsels, will usually bring up to ensure that those matters are delayed. In some of them, we have gone to Supreme Court and back on preliminary issues. We have not even touched the substantive matters in those cases. So those are the causes of delay in the prosecution of ex-governors and other political exposed persons. We have not forgotten about those matters. We are prosecuting all of them in court. Some of them we have taken a number of witnesses. For instance, in the case of former governor of Kogi State, Abubakar Audu, we went to Supreme Court and back on preliminary issue, and the Supreme Court said, go back to the trial court and face your trial. Now we are back to the trial court. We have taken a number of witnesses in those cases. Ditto for Joshua Bariye. We went to Supreme Court on preliminary issue. Now we are back to the trial court. Trial is due to commence all over again. And a number of other governors that we due to court, the same thing applies to them. Look at the case of former governor of Enugu State, Chimaro Namani. We have been in court since 2007. Only recently we have to split the charge. That was the reason why we were able to convict some of the companies that were charged alongside the governor in the same matter. The same governor who has a penchant of going to court to claim that he is too sick to even face trial. When it was time for him to run for the senatorial seat in his home state, he came back from the U.S. to run for senatorial election. But meanwhile, each time his case comes up in court, his counsel will bring up his application with a lot of sophisticated illnesses that will not permit him to come for trial. But when it was time for election, he came back to contest for election. Those are the problems that we face in the prosecution of political exposed persons. Most of them do not want their cases to progress in court.